YouTube channel. I hope you guys managed to watch the previous session I had with Lincoln here. So I'll just introduce him again for those who didn't watch it. So today with me I have Lincoln Majogo, a legal practitioner under the employ of Mishin Como Legal Practice. So we're just going to discuss and pick up on some points that we just didn't pick on the last session on the contract law concerning a contract of sale. So we'll start on basically I don't know any other clauses that we forgot or missed to mention about and discuss about in the last session. I don't know if you can pick one or two.
Thank you very much, Zauda. Well, I think it's also imperative that we discuss the law on double sales.
Okay.
Something which is happening in Zimbabwe, where the seller sells the same piece of property to two different buyers. So it's always important to try and register your property first, as quick as possible, as soon as possible. Which is why you need trained professionals to do that for you, because that then protects you from risks of your property having been sold to another person. So it's always important to once you have signed that agreement of sale, to take all the necessary steps to ensure that that property is then transferred into your name, to ensure that you have maximum protection of your property. Right, and then that brings up the issue of when the sale is regarded complete. Exactly, yes. Because you can only pass transfer if a sale is regarded as complete. In some instances, a clause will be there that says once both parties have signed the agreement, the sale is regarded as complete. In some instances where there is no such clause, the court will then have discretion to determine as to at what reasonable stage can we say that this contract became complete. But you don't want to go there, so you want to have a clause in your contract or in your agreement which specifically states at the time that that sale becomes complete. Is it either when a person takes occupation or when both parties sign the agreement? I would advise that when both parties sign the agreements, to ensure that both parties can read and both parties' rights and interests are protected.
All right, I have an interesting question there. On that note, I've heard about when an offer is the offer is signed and it's also accepted. On that note, are there not any implications concerning that rule on the offer and acceptance?
Offer and acceptance. Thank you very much for that pertinent question. So in other transactions where there is an offer, somebody comes to you and says, look, I'm selling this car, and you accept, you say, fair and fine, I'm accepting. Once you accept, there is a contract. But now parties will then say, fair and fine, we know we agreed to this oral contract, let's then reduce it into writing to ensure that when there is a dispute, you can refer to that paper as an embodiment of what we agreed. So at that stage, you then need to have a clause that specifically deals with when and at what stage does this contract become concluded.
All right, that's an interesting one. So we'll move on to another point that we have here. Many people in Zim currently are registering trusts and are putting their properties, registering them and their estates in trusts. How exactly does this process go, and what are the implications? Are there any benefits and disadvantages of this?
Thank you very much, Zauda. I'm sure you've heard about the new controversial in courts Marriages Act, where people are discussing about the implications of the act, in terms of which maybe a small house, as we call them, may benefit from what we normally call matrimonial property. So there's so many implications to the law of property with regards to these issues. Some person may not want to share a certain property upon divorce. So you're contemplating that at some stage in time there may be a divorce. So if you register that property in a trust during divorce proceedings, that property cannot be attached unless there are special circumstances, very, very special circumstances. But in most cases, that property is protected. So upon divorce, that property is protected. But also, we are coming from a pandemic, COVID-19, which was unexpected, which shows that at any stage anything can happen in life.
Mm-hmm.
You also want to have your children to have protection
Mm-hmm.
of your property
Mm-hmm.
from maybe relatives or
Mm-hmm.
other people.
Mm-hmm.
So it's also important to register a trust
Mm-hmm.
to ensure that your children are protected. Even after you die, that trust remains. So the process is pretty simple. It's simply an agreement that you sign, which we normally call a trust deed,
Okay.
which is supposed to be executed before a notary public,
Okay.
who is a
Alright.
legal practitioner but also registered as a notary
As a
public.
notary.
And
Yeah.
then once we do that, we then lodge it with the deeds. But the most important process is the trust deed. So
Okay.
the trust deed is simply an agreement
Okay.
that identifies the property, that identifies the trustees. So you need to have trustees that you
Alright.
trust,
Mhm.
because some people may then dissipate that property negligently or use it negligently.
All right.
So a trust is very important because it protects your
Your
property
property.
interests and rights even
Alright.
after you die.
All right. That's an interesting one. So, as you heard, in terms of the matrimonial act, you are supposed to act wisely concerning this, probably registering or not registering these properties under trust, because later in life it might actually be a challenge. Anyway, we'll move on to the next point that we have for discussion here. How exactly do people, or can people, leave their properties under a will?
That's another pertinent question. The good thing is we have been having decisions coming especially from our superior courts, the Supreme Court,
Mhm.
making proclamations on these very important
Alright.
issues.
Okay.
I'm sure you've heard about the Chibwada versus Chibwada decision.
Mhm.
I'm not going to go into detail, but the effect of which is to simply say, if you are the owner of your property, you are allowed to bequeath that property or to leave it in a will to any person of your choice. So you
Okay.
can leave that property for the inheritance of someone who's not even related to you,
Right.
someone who's
Right.
not your child, someone who's
Right.
not your
Your
wife or your family.
Yeah.
You're allowed to do that because it's your property.
Right.
But one thing that I need to emphasize about a will is that it needs to comply with certain formalities. And once it fails to comply with those formalities, it is not regarded as complete.
Okay.
So some of those formalities include the age of the person who is bequeathing this property. You have to be above the age of 16. So you can't
Okay.
bequeath that property if you are below the age of 16, unless you have a guardian, but it's above
Okay.
the age of 16. Yes.
All right.
Two, you need to identify that property as yours. So it has to be a property which is yours. You can't bequeath property which belongs to your wife or to your
Alright.
spouse. It
Okay.
has to be property that you have title or rights of.
All right.
The other formalities is basically just when we are doing the agreements to initiate every page, to have witnesses who are
Alright.
present, who are
Alright.
of sound mind.
Okay.
You have to sign that contract without any fear. So someone should not have threatened you and said, if you don't put this property in my
Alright.
will, I'm going to kill you.
Okay.
It has to be free consent
All right.
and knowledge. And most of those requirements are basic requirements that
Alright.
apply to every other provisions of the law. So basically the process is you go to a legal practitioner if you want, or you
Okay.
can do it on yourself, by yourself, but it's always important to have trusted officials. We do the will,
Mm-hmm.
the agreement, and then we have witnesses that sign.
All right.
Once the agreement is executed and signed, we can keep it if you trust us,
All right.
or we can lodge it with the master's office
All
to
right.
ensure that just in
Okay.
case this building catches on fire,
All right.
there's still a record
There's
there.
still a copy there.
There's still a copy there.
Okay. So even if we, for example, I'm to write a will and just leave it at my homestead, it's still fine. It's considered as binding in the event that I die.
In the event that you die, which also brings another important issue.
Mm-hmm.
So even if you go to a legal practitioner, you need to make sure that one of your relatives know about the existence of this will.
Oh.
Because upon your death, if the legal
Okay.
practitioner does not bring it to the attention of the parties that there is a will, well, you know our law
Oh.
of inheritance,
Oh.
relatives are going to be claiming your property,
Yeah.
this and that,
Yeah.
and
Yeah.
your children and your
Alright.
spouse will
Okay.
not have the full
Oh,
protection.
all right.
So
I
it's
see.
always important, I emphasize, to have trusted officials that assist you in this
Mhm.
process
Alright.
and do the safekeeping of your documents.
All right. My last point on that one was it doesn't necessarily have to be registered under the Master of High Court.
It doesn't.
All right.
It doesn't.
That's good.
Yeah, it's just one way of doing it.
All right.
But as legal practitioners, we are allowed to keep
All right.
those views.
Okay.
But maybe just for safety reasons, you can lodge one copy here, you can leave one copy
Alright.
here, one copy
Within
at the
the Master
masters.
File Code.
It's always important to do that.
All right. This brings us to the end of our session. Thank you so much for listening. Thank you so much for joining us. Continue to watch the next sessions, and I hope you don't forget to comment, like, and subscribe. Thank you. Thank you.
Thank you very much.